A cheerful Mamuni Akwaba, a Bam Melodies podcast YouTube channel. So I'm saying, me the story, Ebrel say, a year menzgold, a year Bank of Ghana, SEC, Echo Court, and a Chester Court, no, a ball assembly guya. Na, Embra, menzgold in some no SEC, be more menzgold in some linear CC, no, a menzgold, a year SEC Court, no, Mokache, or Mocastamers, ne say, SEC, the SEC Court, and a more munim say, Assem so quarter, a year in D. Ewofi anayen ka ho asem nti menzgold for executives ne ka say o sisi asem no wo court nti no court di asem ni wi a na menzgold for na omosika no akem no yetu omo na asem ne say menzgold court no yetu menzgold for asem guye na is anan ankuma ye one lawyer bia tese ekuku dambo Ghana Emra menzgold eye men's bank na enyambe dane menzgold enye kese kra no na ono de oka eye enseme fa menzgold ho sambre na ye men's bank na enyambe ye kese no na ono de oka se sa nkrofo no omo ye ponzi scheme ti man nkrofo fo musika nkoto ba emze Ghana for ya so den enti no eye menzgold ekọ court na yato assembly go no na say anase esefata say eye lawyer etchemu dentia eye court no eto menzgold for asem guya because na nkofo bebre e ka say oh menzgold for asem ye de but court ne say menzgold for mo asem enye de intino is anan ankoma ensem mo bi atia say oh we intina court no eto menzgold for asem no eguya inti yenko tie okasa ewo news file so inti yenko tie ensema is anan Ankuma ekikae.
Help us understand what happened.
Well, the action was dismissed on a technical ground.
Okay.
You might recall that I was involved in the HFC matter, where the Supreme Court re-emphasized that if the law provides a procedure for ventilating your grievance, you stick to that procedure. Now, the defendants in this case were the Bank of Ghana and the SEC, the Securities and Exchange Commission.
Right.
The Bank of Ghana Act says that if you're challenging the exercise of the bank's powers under the Act, you go for mandatory arbitration.
Right.
As distinct, there's voluntary arbitration where the parties voluntarily agree to submit their disputes to an arbitrator. But if it's a dispute involving Bank of Ghana in the exercise of its regulatory powers, you go for what is called a mandatory arbitration. You have no option. You have no choice. You cannot file a writ in court. You must go for arbitration. And an arbitral award is, to all intents and purposes, it's almost like a judgment. Once the arbitrators give the award and you register the award in the court, you can enforce the arbitral award. And so it is possible that they can go for arbitration and Bank of Ghana will lose.
Okay.
Then there's an arbitral award that binds Bank of Ghana, and once it's registered in the courts by a simple by a very simple process, it carries the weight of a judgment of a high court and it's enforced as such. You can't appeal against an arbitral award.
Okay.
And so there's mandatory arbitration. And also, if your reliefs sound in public law, which means that it's not a private action between you and I for violating a contract, but you are saying particularly that a public body has not exercised its powers well, then there's another process. It's called the judicial review process, where the originating process is called an originating notice of motion, not a writ.
Okay.
And so if you don't have to mention what is called the prerogative writ, that I'm asking for a certiorari right or prohibition or mandamus, etc., etc. But even if it is in the nature of them, so you could, for instance, go to court and seek declarations. Mm-hmm. But if the court says the nature of the declarations you are seeking sound in public law, and effectively what you're asking for is for the exercise of our powers of judicial review through issuing prerogative writs, then you cannot come to court with a writ of summons.
Okay.
You must come to court because a public law action. You must come to court by way of an originating notice of motion supported by an affidavit. And when it comes to with the SEC, the parallel is that if you complain about them in the exercise of their powers, you go before the hearing panel that is constituted, which can also make findings against the SEC itself. Okay. If you go to the NCA, they also have a panel. A lot of these regulatory bodies have quasi-judicial, or maybe it's even judicial, because it determines the rights of people who sit and hear and is regulated by law. I mean, if you go to before the NCA panel, you appear before no meaner personality than Justice Dateba,
right,
who has given rulings against the NCA itself and some in favor of the NCA. And so this action which went to court was seeking declarations which really sounded in public law, and it was challenging the exercise of regulatory powers by the Bank of Ghana and SEC. Now, I think the first challenge to the Bank of Ghana's powers arising from these was in John Ofori versus Bank of Ghana and Ghana Commercial Bank. I was involved in that, where the court said exactly what I'm saying. That if you are challenging the exercise of these powers, under that there's 141 of Act 930, you cannot come to this court. You must go to mandatory arbitration. And if, however, your claim is in public law, and the court said you may come by originating notice of motion, but we'll look at it when you get there, because if you disguise it as a public law action, but what we are seeing is that you are really challenging the Bank of Ghana in the exercise of its powers, we may decide whether no, actually, still go for arbitration. But the court kind of left that hanging.
Okay.
And that is the same thing, the same principle that throughout the 2-4 case.
Yeah.
Same principle. And it's the same principle that has thrown out the menzgold case, that go to arbitration or go before the hearing panel. You can also decide to test it by coming by in a public law action by an originating notice of motion, and the court will see whether this is really what it is, or it's simply a basic challenge that the law says ought to go before the panels. People could argue that the effect of these laws is that the people are being denied the right to court, and that under the Constitution you have a basic right to go to court, and the High Court has jurisdiction in all of these matters. These have been raised, and the Supreme Court has still said no. Once the law says this is the procedure you trigger to ventilate your complaint, that is what you have to do.
Okay.
So maybe somebody might be brave enough to want to test the Supreme Court again on that.
So what has happened? Where does it leave us, as in customers of menzgold and menzgold itself?
Well, this case, which was in court, had nothing to do with customers of menzgold. This was menzgold challenging the order of the SEC. Now, but the SEC's order is very interesting. The SEC said, don't take any new deposits.
Right.
The SEC didn't say, don't pay your existing customers.
Correct.
Because if your business model does not depend on new customers, then pay the old people.
Right.
Whichever sales you claimed you were, which transactions you were doing in gold anywhere in the world. And it's very interesting that they claim to have been dealing in gold. Their license says buy from only small-scale miners. Small-scale mining had been banned for a year. So where were they getting the gold for? So if there's this gold, mythical gold, that is trading and bringing money on an exchange we do not know about, in a country we do not know about, and you refuse to submit your documents to the SEC to vet, to even decide whether your scheme can be licensed, then go ahead, pay the people, right? And so if your business is not robbing Peter to pay Paul, don't rob Peter, pay Paul. Now, if you can't pay Paul without robbing Peter, then you're a Ponzi. You are simply circulating funds, and that is an illegal investment scheme. So I think that the biggest test to whether or not this was a Ponzi for all of us out here is, were they able to pay Paul without robbing Peter? Now, also, all the Pauls who are unpaid, if your payments, now you are now seeing that your payment depended on robbing Peter, then sorry, you have the classic Ponzi, and the law has come down very hard on it.
Okay. Now, Gillian, we've had repeated use of Ponzi scheme. What are we talking about? Of course, you are in banking, and you should understand these as well. What is it about? So that we are not only talking to menzgold customers, but also potential menzgold-like customers.
Thank you, and morning to your listeners as well. I think a lot of what you've just asked has kind of been referred to in the earlier submissions, because I think some people are aware of what constitutes the Ponzi scheme, and at this stage I don't want to veer into the point of saying this was a Ponzi or wasn't, because there's a lot more information that is required, but it appears to bear the hallmarks of that system where there isn't a fundamental business model, which is one of the questions that you asked. So you're attracting funds on the basis of promising a high return, normally out of kilter with what the fundamentals of whatever economy you're trading in is offering. And you rely on attracting more and more people to pay others. And if the majority of the people that are involved or your clients are comfortable with the concept of maybe just receiving their investment and not taking their original principal, then this can carry on for a certain amount of time until something happens and there's a stop. Referring to what Ace was saying, where as soon as there's a stop, then it means that